we've been able to establish that there's a relationship between an employer and employee. That relationship is founded on the contract of employment, the contract of service, and any injury that occurs in the course of employment has to be compensated for by the employer. This is the Courthouse, and I'm Itohan Olomu-Agbodo, and that's how I welcome you this week. We are going to be taking a look at the other aspects of workmen's compensation, the types of liabilities, and the types of remedies available. We'll go on a quick break. We'll be right back. Welcome back. If you just joined us, this is the Courthouse, and this week, as I said earlier, we are taking a look at the workmen's compensation again. We treated that in the previous episode, and we are taking a broader look at that topic, and we are also joined by this seasoned legal practitioner who started the topic with us. He is Clement, a very erudite scholar, and we are pleased to have you again, sir.
Thank you for having me again.
Okay, so you've been able to give us different scenarios that constitute cost of employment. You've actually been able to give us the fact that there must be a relationship between the employer and employee to even, for the issue of compensation to even come up in the first place. So now we are looking at incidences like an injury could have been minor. It could have been just a cut or just something that could have been easily treated with a first aid box. What happens if that organization doesn't have a clinic or even a first aid box? What happens?
Well, thank you very much. That's, as you're just casting it out, refer my mind to what we call causation, chain of causation.
Chain of causation. Yeah.
An injury that happened, like I said in our last discussion, that when you look at injuries that need to be compensated, it's not just every kind of injury. It might be injury that is related or that is tantamount to affecting the employability of that worker. The capacity to continuously discharge his responsibilities and earn from it. So if the injury will result or degenerate to that point where if he had been working for 8 hours, he will find himself struggling to even work for 5 hours, if not that he cannot even work at all. Those are the kind of injuries that we are looking at. So you now brand it or categorize it, whether it is temporal, it is partial, it is permanent. You know, those are the kind of, depending on the facts and circumstances. And then, like you asked, it may be that the injury, if it has been treated at the time it happened, maybe depending also on the disposition of this employee. Is he working, he or she, is he working in a place where he cannot on his own have access to medical aid to arrest the situation? Maybe because he has been confined, not necessarily by his own volition, but by reason of what he is doing, which means the employer ought to have made provision, like you're talking about, having a first aid or having a well-furnished and equipped clinic for a sick bay for those first aid approaches to be carried out. And upon appraisal of the medical staff there, if they would recommend for the person to be immediately relocated to another or referred to another hospital where he can be given sufficient treatment, that can also be done. In the course of claims, all of this will also be established. But if that is not the situation, which for us, using our own claim to talk about it, it may not be, maybe something that the person can walk home after the incident, and it's expected that the person will take care of himself. And maybe the person does not have the means to take care of himself. And there is a chain of causation comes in. If the person had done what he was supposed to do, would this had, even if his management had not, he may have even reported to the management the incident that happened. And they may have even, maybe his immediate superior would have come to, sympathize with him. But no step had been taken. And he may not have had money. The question is, did he request for it, for funds to enable him go for immediate medical attention? If he did not do so, the reason why I'm going this way is that at the end of the day, even if he's going to establish that whatever injury he has sustained, flew from or, resulted from whatever, in the course of his employment. Remember that the employer is also not denied or deprived or forbidden from having his own defense. The employer is also going to put up a defense. And one of the common law defenses that we talk about is what we call the contributory negligence. So yes, accepted that this, although that does not absolutely, free the employer from liability. But the question is, accepted that this happened, accepted that it was as a result of either our inaction that led to this. The question is, as at the time this thing happened, should you have taken certain steps? Would they have resulted or degenerated to this point it has generated? Maybe a cut in your hand that you did not resort to or seek immediate medical first aid, that now, based on the kind of body system, had now degenerated to cause an ulcer or an infection that will lead to even the amputation of your hand. So by the time you would trace the history, if you had arrested it at the point, would they have resulted to that? If the answer to that would be in favor of the employer, so the court will be made, or whatever tribunal will be made to consider that, yes, accepted that this injury started in the course of employment, but the employee has also contributed to his own fate by not taking the needful action, either to do it. That's why some people, you see that they seek medical aid, and after that, they will bring the bill to their employer if they know that this thing actually happened in the course of my employment. Okay. They don't wait for the employer because it is at their own risk. So they do the needful and then demand for all the documentation to attach to their letter of request for reimbursement. So if the person had done so, the injury would not have resulted or degenerated to the point of the amputation of the person's limb or whatever. So that contributory, the defense of contributory negligence would not help the employer. Instead of maybe paying, talking about compensation now, paying so much, because this person would have come with so much of aggravated damages to ask maybe a tribunal to award in his favor against his employer. And the employer comes in to introduce this, and the court go through the record and found out that, yes, it is true that you incurred the injury in the course of your employment. However, you have also failed to, as a reasonable person, to do what you are supposed to do at the time you're supposed to do it. So therefore, if you're asking for 20 million, if you're asking for 100 million, the court will look at it and say, and have this discretion, because when it comes to particular general damages, the court has its discretion to decide, depending on the facts and circumstances as it was fed with, to now decide what can give to you. So that can lead to what the court will decide to allocate or award as compensation. So in the light of what you have said. So it's not enough that the organization or the employer may not have even the facility to give you first aid. As an individual, are you also confined or compelled to be confined in a manner that you also on your own
cannot seek attention,
cannot get a medical attention? And if so, did you make a request to say you needed it to the employer as at the time this injury happened? Because, for example, if you're talking about a seaman or someone in the middle of the sea, maybe an oil rig staff, an oil company staff, where you've flown into the escravos, for example, apart from, in that circumstance, apart from their own medical section that they have there for first aid activities and all that, you may not have any other one. So assuming that they don't have, imagine that they don't have, so you will not have anyone to resort to. So you will need to, the first thing is, did you request for it?
So the issue of reporting also
Yes,
comes in.
reporting comes in. But if you're outside where you move from your house to your office, and even if your hospital is supposed to have, they did not have, did you on your own? Because you slept over it, with that pain or that injury, that little injury, and you woke up and you saw it was going. That may not be the first injury you had. You may have had some understanding about yourself. So what step did you take as a reasonable person? So if you fail to do so, the court may, if proven that you contributed to your fate, it may affect and hamper whatever damages that may be given to you. Yes.
So what about, there's this other issue of moving a worker going to the place of work, traveling to the place of work. There's this issue of whether if an accident occurs or an injury occurs while the worker is on his way to the organization, the employment venue,
yes.
Any accident that occurs in that situation, who is liable for
when we talk about
treatment?
When we talk about an incident happening in the course of your employment, I would like our audience also to know that course of employment here, like I said in our last session, that it's not only because you are within the four walls of your organization or office environment. It also goes to the extent that from your office environment to either your temporary residence or your permanent residence. So the movement between your office and temporary residence, or the movement from that office to your permanent residence, also encompasses in the course of employment. So if it is established that without more, all that you were doing was moving from your residence, whether within, like you said, temporary, because it's assumed that you may, for example, you may be working in this city where we are, but that may not be your permanent residence. So over maybe the weekend, you may have traveled to your permanent residence and then proceeding to come back to your place of work. Within that, so long as there is no inhibiting act that you carried out, that the basis upon which you are returning back to resume your work, it is in the course of your employment.
Quite interesting, because a lot of cases have arisen based on that particular scenario. But I want to take a listen to our reports and we'll see some of our legal nuggets. We'll be right back. In general, the course of employment has been liberally interpreted by the courts. However, certain exceptions exist to protect the employer from questionable course of employment cases. An employee who is not furthering the interests of the employer is not considered within the course of employment. Further, an employee who breaks the law or violates work rules can be excluded from the course of employment, but it is the burden of the employer to prove that exclusion. In the event that an employee causes an injury to another or another's property, it is necessary to ascertain whether the employee was acting within the course of employment. The employer is legally responsible for the damages if the employee caused them while performing a job. If a driver for a transportation firm is involved in an accident with a pedestrian, for example, the pedestrian can sue both the driver and the firm. Under the doctrine of respondeat superior, an employer can be held liable for a tort, that is, a civil wrong other than breach of contract committed by an employee operating within the scope of the employee's employment. Workers' compensation laws require the payment of compensation from the employer to the employee in conformity with the schedule for a particular category of injury, provided that the employee is injured during the course of employment. The course of employment encompasses the actual period of employment and the period during which the employee, while on the employer's premises, prepares to commence or to depart from work. Welcome back. This is still the courthouse, and we have been taking a look, another look actually, at the Compensations Act, the Workmen's Compensation Act. Who is entitled to compensation? When should compensation arise? And who is obligated to pay such compensation? And our seasoned legal practitioner who has been talking to us is Clement Echo. And you just painted a scenario that if I am going to resume at my place of work, and it is proven that I was actually going to resume to my place of work, and an injury occurs, I am entitled to compensation from my employer.
You are in the course of your employment.
Because I'm in the course of my employment.
Yes.
Okay, so are there any other scenarios that you would like us to get to know about?
Like I referred to in the last session that we have. But before then, I would like also for people, because some people may think when we talk about compensation, originally we had the old Workmen's Compensation Act. But now, in 2010, the president of this country passed or signed into law a bill. We called it the Employees Compensations Act. By its title, you know that it is prone to protecting and advancing the interest of the employee. And the employee here does not necessarily mean those who are working in public service. Both in public and private service, they are all covered and protected under that. And it is that also law that gives the employer, and because one of the good things about that law is that it created an insurance scheme whereby in the event where some employers, though they may be willing to provide compensation, they may not have the means at the time an incident may happen. So how do you do it? You know, if you fail to plan, if you fail to plan, you plan to fail. So the government has come in to set up a Nigerian Insurance Social Trust Fund, whereby employers are mandated within the first 2 years of that law coming into effect, that every employer is entitled to pay 1% of the total monthly amount, sum that he pays to his staff. Just 1% of it remitted to this scheme, so that in the event where these incidents happen and they cannot, an application can be made, and that scheme can be used to compensate the individual who is affected. That is one of the beautiful things of that law. Wow. So constantly you are expected, although the employee also has an obligation to notify his employer as to the incident within 14 days of its occurrence. Okay. And then within 1 year, he is expected to make application for this compensation. These are part of the obligation that goes to the employee, as well as the obligations of the employer in that. And depending on the scale of damage or injury, the employer or one of the damages, the scale of damages that can be, or compensation that can come to an employee, can range from 30 to 90% of whatever monthly payment that usually comes to that. But when we talk about 90%, you're talking about incidents of maybe death. You understand that in that case, you will not say because the person is dead, so he will be denied. No, his dependents or our dependents, depending on whoever is affected, can come in to also make claims for whatever they have. So going forward, talking about other incidences that because of our viewers, most of them, like what we've just cleared the air with, they would think that maybe because until you get to the office and sign, that is when you are in the course of your employment. You remember last week we talked about, last session we talked about the issue of the police officer who was cleaning the gun. You understand? Somebody may say, what is the relationship between his house and his office when he's cleaning the gun in his house? Who knows what he had done that led to whatever injury that led? But you could see how the court, upon painting the scenario and the circumstances of his office, why he could not drop the gun. So that every case, when it comes to the workman or the employee compensation, every case must be looked at, you know, specifically. One case may not, except where you have facts and circumstances of a uniform manner, but most times it may not be, because there may be one thing or the other that has happened. So if it happened, because you have to paint the scenario that led to whatever, I remember the last Latin magazine you talked about, res ipsa loquitur. The facts speak for itself. If an injury happen as a result of an incident, and you come and look at the incident and narrate, and you look, the mere fact that you look at it, the fact of it speaks for you. You don't need to contest. You will know that this one happened as a result of this. So with those ones, you will know whether the employer is rightly and expressly obligated to do what or liable to pay compensation. Most times where you have difficulty is when the injury happens maybe outside the office environment, where a staff or an employee is sent on a mission, on an errand, whether it is within the same city, within the same state, or within the same country. It does not matter the distance, so long as it can be proven that he or she was carrying out the obligation or the assignment of the of his master, of the employer. He is still in the course of employment. So anything that happened within that period of time, the employer will become vicariously liable if it is not to the employee himself directly, to a third party, you can also claim, except of course you can prove that something has happened in between that should cause make a break to the causation.
Okay, so you mentioned the fact of a third party,
yes.
And I'm particularly interested in that third party scenario because now we've been looking at the employee's injury, employees during the course of employment and the like. When an employee within the confines of his office environment and within the course of employment injures another employee, you talked of vicarious liability. Can you just clear the air? Who is liable? Who can be sued in that regard? And I'm an employee, a fellow employee gets injured because of my action. What happens? Just by way of wrapping up.
Well, it's again very clear. One, under common law, we have what we call common employment. In fact, that is one of the frustrating defenses that employers initially had to use to frustrate the move of employees to get compensation, because you said, come on, we are working together. You should have known that by reason of us working together. Something is not only good things that, after all, the good things that have been happening between us, have you ever complained? Why is it that you should not also envisage that humans may be liable to make errors, and those errors can lead to mistakes? So employers under the common law have used that doctrine of common employment to say, yes, it's not that we are denying that this injury did not occur. It occurred, but it occurred as a result of their work together with another fellow employee. So it would not be reasonable for you to attach the liability of a fellow employee to me, to us, because the two of them know. It's either yours, except of course if the employee can prove that this fellow employee that caused the incident that led to the injury was grossly incompetent to the knowledge of his employer. And maybe that has even been brought to the attention of the employer, and the employer failed to do anything to remove that risk from among them. So in that case, the fact that you raise a plea of common employment would not, because you wouldn't have deliberately or knowingly brought an individual that will be or impose or stand as a threat to other. Remember, the international standard is that not only will you provide a place of work, you provide a place that is safe and conducive with all that is required, depending on the nature of work you carried out. So individuals also that must come in must be individual within that fit that procedure.
Okay, thank you so much, sir. Can you just give us your Latin maxim for the week? We are wrapping up.
I would like to borrow the one that you use, res ipsa loquitur. The fact speaks for itself. And
okay,
when you see
I'm relying on the res ipsa loquitur, the facts speak for themselves. You get to find out more Latin maxims in our bar book segment. Stay with us. Well, that's the much we can take this week on the Courthouse. We had a very interesting conversation with Clement Echo, a legal practitioner, and I must say thank you again for being in the Courthouse. And of course, we'd like to hear from you. You can send your questions. We want to provide answers to the questions that you have. So you can log on to our website on www.loverplus.tv. You can also send your email to info@loverplus.org. You can send comments to the number showing on your screen now. It's Olomu-Agbodo. I say, don't just get mad. Go get a lawyer. Bye for now.